Well, good. This is about the board-superintendent relationship. The board and the superintendent, of course, in any school district form what's commonly referred to as the leadership team. And there is absolutely no doubt in my mind that that relationship is the key to the success of the school district. In terms of what we're going to talk about, I'd like to begin with a few overriding truisms. Then we'll go to the laws that are primarily applicable to both the board and the superintendent and continue with their respective roles and responsibilities, followed by some specific examples that I hope will illustrate those, and finally some practical considerations before we reach conclusions. So with that in mind, beginning with the truisms. The state is sovereign. That's a concept that goes all the way back to the Law of Kings. And the state very much is like the king, in New York particularly. School districts and school district officials exist only because the state legislature created them. A school district has no inherent power. It's an entity of delegated authority. So if anyone were to approach you with an unusual question, it would be best first to determine whether or not a school district has the authority to act in the area of the question. Because if it does not, then it's an action that ought to be avoided. The Board of Education, of course, then has no inherent power. It only has the powers that are delegated to it. And the same is true of the superintendent. He or she also has no inherent power, but is an official of delegated authority. The board is a corporate entity. As suggested by the quote, the power of the board belongs to the body and not to the members. A board, when it acts in its corporate capacity, is acting the same as a board of any corporation. Its acts are required to be captured in resolutions that are duly moved and acted upon by the board, and with respect to a Board of Education, particularly in public. Generally, board members have no individual authority to act. However, an individual authority can be delegated responsibility by the entire board to act. And in that capacity, that individual actually represents the board. The superintendent, of course, is appointed by and reports to the board. In city school districts, interestingly, superintendents are actually non-voting members of the board. In other districts, superintendents, however, have the right to speak, which in essence makes the superintendent part of the body because that right, of course, requires the superintendent's presence. Now, the only possible exception, and this is usually created by contract, is when the board is talking about the performance or the evaluation of the superintendent. Superintendents, however, it has to be remembered, also are obliged to the state. They all hold certificates, which empower them, if you will, to perform the duties of their office. That certificate, that license to act, carries with it some responsibilities to the state which grants that license. Okay, let's talk a little bit about the major categories of board authority. First, boards determine the courses of study and approve the content of those courses. Boards select textbooks, something which sometimes is honored in the breach, but I would certainly suggest that if you are advising a Board of Education as a superintendent, it would be wise to put those textbooks before the board for consideration. To oversee the admission, grading, and advancement of students. This is particularly important with respect to issues involving the residency of students. To employ professional and support staff. The board certainly has the final say with respect to that. We'll talk a little bit more about that in a couple of minutes. The boards also buy and sell things. The slide suggests that we're talking about purchasing, leasing, maintaining, and insuring, but the board also has the ability to purchase things, to prepare the district's budget, and finally to establish policies and to adopt bylaws, rules, and regulations which actually have the force of law. So let's talk about the superintendent a little bit. The superintendent is in the implementation and enforcement business. He or she recommends curriculum, methodology, textbooks. But remember, of course, the board has authority in this area as well, so this is kind of a shared authority. The superintendent certainly supervises and directs the educational program of the district, manages all district personnel, enforces provisions of the law related to the operation of schools, and of course performs duties as assigned by the Board of Education. The superintendent is always under the direction of the board and is subject to the board's bylaws. Okay, more about roles and responsibilities. This is a little chart, and I think it will help you focus and compare the respective roles and responsibilities of the board and superintendent. The board, of course, focuses on the ends. The superintendent, on the other hand, focuses on the means. The board addresses things like what. The superintendent addresses things like how. The board certainly has to address the why of any action. The superintendent, many times, however, gets to focus on and implement by determining the when of the action. The board is interested in how well the action was performed. The superintendent, on the other hand, might be better focused on where the action will take place. The board is always concerned with how much the action is going to cost. The superintendent, on the other hand, while he shares that concern, is perhaps even more concerned by whom is the action going to be performed. The board concentrates on things like vision. The superintendent concentrates on objectives. The board focuses on goals. Superintendent concentrates on plans. And finally, the board, of course, enacts policies. The superintendent implements those policies by taking action. So, some example. Let's talk a little bit about the appointment of teachers and other certified folks, including administrators. It's a shared authority. It takes two. Both the board and the superintendent must act on any such appointment. The superintendent, to begin with, must make a recommendation before that appointment can be acted upon. The board, on the other hand, has to pass a resolution which implements that recommendation, that approves it, that puts it into force. But again, the board can only act on persons who are recommended by the superintendent. Also, this is true with respect to the termination of any employee or the granting of probation or tenure to any employee. It takes two. So it's a very good example of shared authority. Let's range into the area of collective negotiations. It's another example of shared authority. Under the Taylor Law, it would appear that the contract is between the superintendent and the union involved. And while that probably is literally true as you read the statute, practically speaking, that contract is between the school district that is being represented by the superintendent in the negotiation and the union. Because certainly we would not expect the superintendent to pay the salaries and all of the other things that collective negotiations entail out of his or her own pocket. However, under the statute, with respect to this shared authority, any additional funds, and I mean if it's a nickel, if that contract costs any more than the contract that preceded it, the board absolutely must legislatively approve that contract. So it takes the superintendent to negotiate it, to bring it to the board, and it takes the board to legislatively approve it before it becomes binding on the school district. And of course, there is an exception. It doesn't happen very often, but I've seen it, where the superintendent actually cedes his right to ratify a contract as opposed to just permitting the board to legislatively approve it, and grants ratification authority to the board itself. I don't think that's necessarily a good idea. I think the superintendent should reserve the right to ratify that agreement. Now, of course, if the superintendent comes to the bargaining table, that right of ratification, of course, is ceded because the superintendent will have participated in the bargain. Okay. So another example concerns the suspension of employees. Now, that under the statute, which is incidentally Section 1711 of the Education Law, is imposed by the superintendent but only until the next regular board meeting. At that point, the board receives the facts that are related to that suspension and can, if it wishes, discontinue that suspension, or hopefully, trusting in the judgment of the superintendent, continues that objection. But nonetheless, the board at that point is obliged to act with respect to that suspension. Course content and textbooks, we talked about that a little bit before. Those are normally recommended by the superintendent and they are adopted by the board. It's not exactly a shared authority because it's unclear as to whether or not the board can adopt this textbook without the superintendent's recommendation. But certainly, as I read the education law, it is more consistent with a textbook to be adopted only when it is recommended by the superintendent. And of course, once that textbook is adopted by the board, the utilization of that textbook is implemented by the superintendent. Legal proceedings. Another example. A superintendent does not have the authority to initiate a legal proceeding on behalf of a school district. Now, he certainly has the authority to respond to a legal proceeding that is initiated by others, but a superintendent cannot commence a legal proceeding without the board. It requires board action. However, the superintendent, again, is the implementer. Once that action is taken, it is then up to the superintendent to ensure that that action is implemented by the appropriate commencement of the legal proceeding. So how about problems with teachers, administrators, and staff? How would you think that the superintendent and the board's respective authorities mesh in that circumstance? Well, to start with, the superintendent certainly answers to the board. We've established that already. The board, therefore, should raise its concerns about employees to the superintendent. It would be inappropriate, in my view, for a board member, for example, to go directly to a principal or some other administrator, or perhaps even to the problem employee, him or herself, and raise that issue. That only should be done in conjunction with the superintendent. And when the board member does raise that concern about the superintendent, and certainly out of respect for the privacy of everyone involved, that discussion should take place in an executive session of the board. It's certainly a good way to avoid micromanagement. Executive sessions now. Since we raised that topic, the important thing to remember about executive session is that it's a privilege that the board has. It's not a right. Sometimes the question is then asked, well, what about transparency? We can't have the board being seen as acting always in secret and out of the eye of the public. And there's a point to be made there. But there are only 8 topics that can be covered in an executive session. The slide lists them. I'll go through them quickly. Matters which will impair public safety. Matters that may disclose the identity of a law enforcement officer or an agency or perhaps an informer. And these are all real cases, folks. We've dealt with those frequently over the years. Information relating to current and future criminal prosecutions or information that would imperil the enforcement of the law. Proposed pending or current litigation. Collective negotiations, a very common topic for discussion in executive session. Here's one. It's a long title. It's often condensed by boards to be labeled as personnel matters. There's nothing in the in the public officers law, which contains the open meetings law, that says that personnel matters can be discussed in executive session. The statute actually reads the medical, financial, credit, or employment history, or the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of particular persons or corporations. Now, you don't have to regurgitate, that whole business, every time you go into an executive session, but you ought to pick out the key words that are going to be the subject of the discussion and use those in the motion to go into executive session. The preparation, grading, or administration of examinations, another topic. And finally, the proposed acquisition, sale, lease of real property, or the sale of exchange or securities. Those are the matters that can be discussed in executive session. So, while transparency is important, as the slide suggests, so is the do more harm than good rule. If not going into executive session is going to interfere with any of those 8 very important exceptions to open meetings, I would suggest that the board, every time, should utilize the exception. At the end of the day, however, it is the board's decision as to whether or not an executive session will be undertaken or not. So, some practical considerations about all this. We'll begin with the superintendent's contract of employment. My favorite Samuel Goldenism, of course, is on the slide. A verbal contract isn't worth the paper it's written on. And that's a truism. And not only are people more thoughtful when they put things in writing, it also presents, I think, an important opportunity with respect to the leadership team to establish mutual goals and objectives, to clarify the relationship in order to minimize any potential for conflict. The contract also ought to provide clearly defined roles and responsibilities for the superintendent and the board. And I would say particularly for the superintendent. And one way in which that can be accomplished, I think a very good way, is to actually attach a job description, a fairly definitive one, to the contract so that later on the roles and responsibilities of the parties will be clear. Another way I would suggest this business of entering into contracts and containing job descriptions is to avoid micromanagement. Micromanagement, I guess, is a very common term, and I used it once before. Perhaps it deserves some definition. In my view of the world, this is when a supervising board actually moves from the overriding responsibilities and roles that it has into the roles and responsibilities that are reserved for the superintendent. In those circumstances, it would seem to me that the relationship can really not survive very long. Now, the dynamics of this relationship require communication. It's important to have a shared understanding, even if you don't fully agree on all of the issues. And a little later on, I'm going to share a quote which perhaps will illustrate that point. Certainly, the successful implementation of the board's policies is dependent on the board and superintendent communicating. This really will result in the best programs for students and also the efficient use of the district's resources. At the end of the day, the whole piece is about trust and confidence. And it's mutual trust and confidence. If that does not exist, it would seem to me that the parties ought to think about altering the relationship in some way, perhaps permanently. Of course, that trust and confidence has to be between the board and the superintendent. And it's important in considering this relationship to think about how that appearance of trust and confidence is perceived by others, because the morale of your entire organization, I submit, depends on that. You don't want to see this. It's a good cartoon, I think. I think it very well illustrates the point. The bear doing the pointing should never be either the board or the superintendent. In the end, the goal ought to be that the law regarding the respective authority of the board and superintendent is something that you just shouldn't have to worry about. The board, of course, exists to be accountable that the organization works. The board doesn't have to control everything, but it should, as the slide suggests, control the definition of success. There's a principle called the one-voice principle. It doesn't require unanimous board votes on everything, but it does require that all of the board members respect the decisions of the majority. It leads to clarity. And the statements by individual board members are not going to be, in those circumstances, mistaken for the will of the board. There should rarely be, as the slide suggests, a minority opinion. Now, does that mean that a board member should never suggest that some matter that's important should be reconsidered at some point by the board, perhaps inconsistent with an earlier decision? It doesn't mean that at all. But there is a forum in which that should be done, and that's the board meeting. That reconsideration shouldn't be taking place as a result of board member statements out in the community. Practically, and I often hear this quote, the board has but one employee. And practically that is true. Technically it's not, because as you'll recall, it takes both the board and the superintendent to appoint folks. To elaborate a bit in terms of who works for who, particularly who works for the board, depending upon the size of the district and the number of folks it employs. A general counsel, for example, works for the board. It's also true about retained counsel. Retained counsel's first responsibility is to the board that retains counsel, not to the superintendent, not to any employee, but to the board and perhaps to the entity, which is the way I like to think about it. The responsibility of board counsel is to the district. Of course, the board has a clerk. The clerk reports directly to the board. The board also has a treasurer. The treasurer reports directly to the board. The board sometimes has its own internal audit department. The auditors report to the board in that circumstance. Generally, those are the folks who have direct report to the board. But on the other hand, remember, in the exercise of their joint authority, the superintendent and the board literally employ everyone in the school district. The tone at the top. Culture matters. The culture of the governance team particularly matters. It should be respectful. It needs to be reasoned and honest. It needs to be open. And it certainly needs to be transparent. What to consider when a team isn't working well are sort of the following. It's critical that communication be open. You might want to achieve that perhaps by engaging in a workshop meeting between the board and the superintendent. Now, that's a meeting that doesn't have to take place in public under the Open Meetings Law, provided that the board is not transacting district business and is rather talking about the relationship between it and perhaps in and among its members and the superintendent. That's a perfectly appropriate workshop that can take place, not subject to the Open Meetings Law at all. The idea, of course, is to focus on problems, establish ground rules, and as I said, it's not subject to the Open Meetings Law. You can sometimes consider to change bylaws. If there is a bylaw that interferes with the relationship, well, perhaps that bylaw ought to be revisited. It's not a bad idea to revisit such bylaws, as it's not a bad idea to revisit any policy that's on the district's books. Certainly, if it's current, that's fine, but it needs also to be considered in the context of the relationship. How well does it work? Too often, I see boards simply adopt policies that are recommended by various policy drafting bodies. That is not a good practice. A policy should not be adopted, in my view of the world again, unless that policy fits the district. Certainly, if you're going to have a formal process with respect to changing your bylaws, well, the Open Meetings Law does apply to that. So if you get into the policy business, then certainly that cannot be undertaken in just a workshop session. Establishing board protocols or a board code of conduct is not a bad way of addressing problems with respect to the leadership team. Sometimes using a facilitator may help. It's been my good fortune over the years to help boards and superintendents sometimes in that context. So some suggestions about it all. I think it's important for both the superintendent and the board to identify their core values and then not only communicate them, but live them. The core values of the Army, of course, are very well known: duty, honor, country. And as great as those are, I'm also rather disposed toward the Air Force's core values, which are integrity first, service before self, and excellence in all we do. Not bad core values to consider. Now, they're just examples. The board's core values, of course, can be different. But again, as we said before, it's important to identify what your core values are and to live those core values within your organization. In terms of accountability, we hear that a lot. Breaking it down a little bit, it requires folks to be definite about performance expectations. Whether you're the board or whether you're the superintendent or whether you're a principal evaluating an employee, you need always to be definite about your performance expectations. Assign those expectations. Make them clear. Talk to people about it. Check to see that the expectations are being met. Those are the three keys. Clear and timely communication, of course, is a suggestion that I think pretty much has permeated what I've been talking about thus far. The superintendent that I know fairly well and is a good friend used to like to use the quote about beating the kid home. And what that was all about was that he preferred to have mom and dad hear about the problem from him as opposed to hearing about the problem through the eyes of the kid. In as much as the kid's perception of things is not always as clear as the superintendent's. When you do communicate, it's important, and this goes back to the transparency piece, to talk about the good, the bad, and the ugly. If you don't talk about the warts and all, someone else will. You can just count on it in the public sector. Concentrate on efforts on continuous improvement. If you're a board of education, that's about setting the ends. If you're the superintendent, it's about setting the means. The presumption of regularity is something that I like. It's a presumption that folks who you trust will make recommendations that are valid. And if that trust and confidence exists between the board and the superintendent's recommendations ought to be met with that presumption of regularity. Unless and until it is affirmatively demonstrated that there is something wrong with that recommendation, again, in my view of the world, the board should give every consideration to adopting it. Now, it runs both ways. The superintendent also has to regard the board's suggestions with the presumption of regularity. These are folks, these board members, who have given up quite a bit to serve on the school board and are making some sacrifice and do so in most cases without any compensation. Certainly they deserve the presumption of regularity because just by virtue of their having been elected, they've essentially earned it until such time, of course, that should the relationship break down, one party or the other does not deserve that presumption. Another suggestion is to expect accountability, but it needs to be tangible. It needs to be concrete and specific. The notion of some amorphous concept entering into this really has little place. Another good suggestion: thank people. Whether you're a leader at any level, it's important to thank folks who are working for your organization. Don't seek credit for what they do. Give the credit away. And when we talk about a board, I always like to remind them that they are the Board of Education. And that ultimately is the mission. It's not the Board of Employment or the Board of Purchasing or the Board of anything else. It's the Board of Education. Now, all those other things are important, But if they do not serve the ends of education, which is the mission, then something's very wrong. So, some conclusions. One of my favorite quotes, I mentioned I was going to allude to it earlier. If two men on the same job agree all the time, then one of them is useless. If they disagree all the time, then both are useless. Think about that in the context of the board-superintendent relationship. Here's another one, perhaps a little more positive. It's one of my favorite Henry Ford quotes. Coming together is a beginning. Keeping together is progress. Working together is success. And a piece that I almost end every presentation with, if you first don't succeed, you'll get a lot of advice. I hope that if you ever have occasion to apply this advice, it will be helpful. Thank you.